Let's have a look at some issues that we need to be aware of when it comes to damages. The first issue is regarding liquidated damages. Remember, liquidated damages refers to damages that are specified, so the estimated amounts are specified in a contract, and the resulting breach associated with these damages would be specified. Usually, a contractor would be liable to pay these damages because of their delay in completing the construction works. In certain cases, the court will deem LD clauses to be ineffective. What's an example of such a situation? Well, if the contractor can prove that the LD estimate is not an accurate estimate, pre-estimate of the loss that is likely to be incurred by the principal, then in this case, the court might deem that LD clause as merely a penalty, and because of that, the LD clause would be ineffective. So this is something very important to be aware of. Second issue is where a principal faces a situation where the liquidated damages are less than the general damages. So they'd inserted the specified amount in the contract, but later on in the project they found that there had been an accumulation of a lot of damages, general damages, unliquidated damages, so the amounts of which have not been specified in the contract, and these outweigh the amount that had been specified, the LD clause, if you like. What would the principal do in a situation like that? Well, if you were the principal, you'd of course want to claim the highest amount, which is the general damages amount. But sometimes the way in which the LD clause is written in the contract, it can be implied that it extinguishes the right to claim such general damages. So it all depends on how the courts interpret your LD clauses. And the authority case over here is Adapt Constructions and Whitaker, a very recent Australian case, the facts of which are very similar to what I talked about. Third issue is regarding what is referred to as the limitation period. So what is the limitation period? It's the period after which the right to claim for damages would be extinguished, specified in statute. So the relevant statute over here is the Limitations Act 1969. For breach of contract, so in contract law, you're looking at 6 years from the date of breach. If you're looking at torts, so negligence, it's 6 years from when the damage is known or manifested. The final issue that I'll talk about in this video is when there are no damages. Okay, so there is a breach, but there are no damages. So let's say, for example, you received the wrong materials. They still do the job. They still have the same features, and they resulted in no loss in value for you. There's nothing to rectify. What can you claim in this case? There's a breach, the wrong materials, but there's no damages. In such cases, the court would order that you receive damages, but these damages would be labeled as nominal damages. So they're pretty much of a very low value, $25 maybe or something like that. Very nominal. And it's a situation that happens when there's no actual estimate of any damage that the plaintiff had incurred.